Welcome to Constitution Day in the Robert H. Jackson Federal Courthouse. I want to introduce the president and CEO of the Robert H. Jackson Center, Kristen McMahon. She's joining me. And I am Greg Peterson, the founder of the Robert H. Jackson Center, which is located in Jamestown, New York, an hour and a half from here. And we're delighted to be part of, and as the program indicated, along with a lot of extraordinary individuals, and I will be introducing a few of them. I thought I'd take time before the event to introduce the subject of Robert H. Jackson. You just walked in from your various schools, and you walked into the Robert H. Jackson Federal Courthouse. You just received a book. Did everybody get their book? Authored by Gail Jarrell on Robert H. Jackson. And I'll try to give you a little bit of a primer about who he was and why the courthouse was named after him. A process which, when the courthouse was established and created, it took an act of Congress in order to designate the name of this federal courthouse. And they chose the name, the Congress chose the name. Congressman Higgins proposed the name. Senators Gillibrand and Schumer endorsed it, and after it was passed by Congress, and then in turn was signed by the President of the United States to be named Robert H. Jackson. And you might say, who's he? Fair question. I'm going to give you a little bit of a Reader's Digest on him. He was born in 1892 in just outside of Warren County, Pennsylvania, which is just over the border in New York in the southern part. And at age 5, in 1892, and he was age 5, moved to Frewsburg, New York, which is right over the border, and that is where he went to high school. He went to high school, and there he graduated from high school. He was the valedictorian at Frewsburg High School, class of 7. But who's counting? He's the valedictorian. So he was the valedictorian and then went and spent his 13th year in Jamestown High School, which is where I'm from. And there he spent 1 year at Jamestown High School, and that's where he learned, and you will learn about him when you read the book, that he thinks regarding forensics, regarding debate. He was an individual who taught himself. His dad was a farmer, his mother was a homekeeper, so he read for the law and was a man of that integrity. Now, he never went to college, and never graduated from law school. He only went there, Albany Law School, for 1 year. So he's a unique individual because he read for the law, which you could do. And he practiced, and therefore he passed the law at the earliest age possible, age 21. Age 21, he started practicing law in Jamestown, New York, and he represented the folks who were union members. He represented folks who were corporations. He did a general law practice. In 1918, he came to Buffalo, New York. And there he represented railroad company interests. And there he literally would walk from his apartment right through this, where this location is, to practice law, and his office was in the Ellicott building. And there he was here for 2 or 3 years, and then he went back to practice law in Jamestown, New York. And then he got into public service in 1934, where the President of the United States, Franklin Roosevelt, asked him if he would like to come to Washington to become the attorney for what we now know as the Internal Revenue Service. What's his connection to Roosevelt? In 1910, he went to Albany Law School, and there he met State Senator, a guy named Frank Roosevelt. And through that process, as they got to know each other, they were both Democrats. Chautauqua County, the Democrats are really rare. Democratic lawyers are really rarer. And so that was Jackson's political background. He got to know this state Senator Roosevelt, who in turn became a governor, Franklin Roosevelt, who then became President Roosevelt. And then from 1934 through 1954, he became a public servant. He worked for the Internal Revenue Service. He worked for the Department of Justice. He was the answer to a Jeopardy question. Anybody watch Jeopardy? Anybody here? Recently, they had the final Jeopardy question. Name the only person in the history of the United States who was a Solicitor General, Attorney General, and a Justice of the Supreme Court. And who was Robert H. Jackson? Correct answer. And it happened to be the final Jeopardy question. The person won. How cool. And that's the guy who never went to college, never graduated from law school. You'll read about this in this Gail Jarrell book. And went on to a very meteoric rise in public service under the aegis of President Roosevelt. While he was a member of the United States Supreme Court, he was involved in such cases as Brown versus Board of Education. Anybody heard of that case? Brown versus Board. Barnett, West Virginia versus Barnett, the Korematsu case. He wrote opinions that are to this day probably the most famous opinions in the history of the United States Supreme Court. He, in fact, is deemed to be one of the great writers of our time. I'm not saying it because I am biased, of course, but Chief Justice Roberts, Chief Justice Rehnquist, Sandra Day O'Connor, Justice Ginsburg, all were at the Jackson Center and all talked about Robert Jackson's ability to command the King's English. And that's part of what Robert Jackson from here, from Western New York, is known for, part of why he became notable, part of why he became the subject of Congressman Higgins' recommendation to name this courthouse. Now, in addition to Brown versus Board of Education, West Virginia versus Barnett, Korematsu, steel seizure cases, these are cases, but they stand for principles which are very important today. When anytime the president signs an executive order, and the first hue and cry when the President Trump, President Obama sign is the Congress says he doesn't have the power, it's unconstitutional, et cetera. Well, is it or isn't it? Justice Jackson wrote an opinion in 1952, which is the gold standard. Justice Jackson did that. Fred Korematsu, Japanese-American internee, was found guilty for violating the order for all Japanese Americans to go into internment camps. That was a case which Jackson wrote a dissent. That means he was against the opinion, which the opinion actually said it was constitutional. But that dissent is probably one of the most famous opinions there is today on bullying, racial profiling, etc. Brown versus Board of Education, of course you know what that was about. He was intimate behind the scenes in making sure there was unanimity in Brown versus Board of Education. So these are cases which have a huge impact. They're from a guy who's from this area. He was in school just like you folks. You'll read about him in this Gail Jarrell book, and you're going to learn about him today. When he was the U.S. Attorney General, he was the Attorney General in 1940 under President Roosevelt. He wrote a wonderful, he gave out a speech to all the U.S. attorneys, which would have been people like you're going to meet today, U.S. Attorney James P. Kennedy. He's going to be here. U.S. Attorney James P. Kennedy will be here speaking. And Justice Jackson spoke to folks of that office and told them about prosecutorial discretion, the fact that nobody has more power over individuals than the U.S. Attorney, because they can decide when to prosecute, when to go after an indictment, not go after indictments. These are the decisions, the conversations which come up in Jesse Smollett. They come up with Epstein, you know, when to prosecute, when not to prosecute. Those are decisions made by the U.S. attorneys. We're going to learn a little bit about that today. Not only Jackson's influence on the decisions that were made by U.S. attorneys, but we're also going to learn about a particular fact pattern that both the public defender Marianne Mariano from the Federal District Court, and U.S. Attorney Kennedy will be part of. We're also going to hear from University of Buffalo Law School professor Matt Steilen, who will talk about Jackson. He'll talk about constitutional law, and all of which impacts you. So when you, in fact, read the newspaper and you wonder what happened to Jeffrey Epstein, what happened to Jussie Smollett, what happened to a variety of folks, whether they were prosecuted or not prosecuted, cases were dropped. Those are discretionary matters which the U.S. Attorney has power over. And the individual who, in fact, set the stage for that discretionary prosecutorial discretion and gave the guidance to it all was a guy named Robert H. Jackson. It's Robert H. Jackson, the name adorns the courthouse. Is the name that's on your book. It's the name you'll read a little bit about in the program, and it's something that you should be justly proud, because where you are today is, in fact, the ground upon which Robert Jackson walked. So with that, I'm going to stop as the introduction and see if anybody has any brief questions before we start in 5 minutes. Any questions, folks, about Jackson, why you're here today? You know, you read the Constitution when you walked in. It was etched on the windows. Hopefully you'll be good. You'll do well on the test, which will be before you get to the meal today. Did you know about that? Did they tell you about the test? Yes.
How old is he?
Pardon?
He was 62 years old when he died. He died in 1954.
Thank you. Thanks for the question. So you have 62, and died of a heart attack. And the Supreme Court, and was up until recently one of the last people to actually die while actually serving the office. He had 2 children, and he had 8 grandchildren. And 2 of the grandchildren are on our board at the Robert Jackson Center, which is, again, located in Jamestown, home of Lucille Ball and Roger Torrey Peterson and National Comedy Center, among other things. Good question. Thank you. Yes? Yes, you can read for the law. You can become a lawyer without going to law school. It's really hard. And you have to study for the law. You have to work in a law office. And I don't recommend it, just because you'll be very frustrated. It'll take a long time. But yes, you could. Totally. And Jackson never went to college, so there's 0 days he went to college. He went to law school. He went to Albany Law School for 1 year, and then came back and read for the law. He read for the law. He worked in a law office in Jamestown. Technically, you can do that, but I don't encourage it.
All rise. United States District Court for the Western District of New York is now in session. The Honorable William M. Scrutiny presiding. Over to the witness stand, the other side.
Judge Lee, it's only because you're used to sitting first in your courtroom, and then you sat when the rest of us were standing.
You're absolutely correct. You're absolutely correct.
All right, please have a seat, everybody. All right, good morning, everybody. Okay, it's really my pleasure to be able to welcome all of you from different local schools here in our area. Hutch Tech, actually Judge Fascio is an alum of Hutch Tech. Buffalo. All right, the Buffalo Academy of Visual and Performing Arts, are you here somewhere? All right, welcome. Canisius High School, you must be here, I think, right? All right, good to see you. And the Emerson School of Hospitality. How hospitable are you today? All right, terrific, terrific. Great day today, and we're really, really thrilled to have you all here this morning at the Robert H. Jackson United States Courthouse. My name, as you heard already, is William Scretany, and I'm a federal court trial judge here in the Western District of New York. We have 94 districts in the federal system. We are one of those 94 districts. I was appointed to my position or my office by the late President George Herbert Walker Bush, President Bush 41 back in 1990, a lot of years ago, after a full Senate confirmation of relating to the nomination to become a federal judge. So I'm honored still to be a federal judge and to be here this morning. Today, as a federal judge, we have the honor of hosting you and the American Board of Trial Advocates, or ABOTA, as they present their 7th annual, and you can see that on the screens, the monitors, the 7th annual James Otis Lecture to commemorate and recognize Constitution Day. Before I get into just a couple of welcoming remarks, I do want to introduce to you all those very distinguished gentlemen and ladies that you saw enter the courtroom just a minute or two ago. And they will be participating in our program, and you will get the benefit of their experience and their wisdom and their leading of the discussions that will follow today's program. I want to start, though, with the judge that took the seat first, Barbara Johnson-Lee from Buffalo City Court. The reason I'm introducing her first is because I forgot to introduce her last year. Right? So I'm trying to make up for that. I embarrassed her in the first instance, and I'm trying to make up with her now by introducing her first. But because we're in federal court, I'm going to take the liberty of introducing our federal judges first. We have the Chief Judge from Bankruptcy Court, Carl Buckeye, and also from Bankruptcy Court is Judge Michael Kaplan. In front of me, to my left and basically centered to you, but to your right a little bit, is Michael Romer, Magistrate Judge, Leslie Fascio, that distinguished alum from Hutch Tech, our Magistrate Judge. You know, really, his head's big enough. You know. Judge H. Kenneth Schrader, who. No, I understand. I understand. Judge Schrader, our magistrate judge, and soon you will hear from the Honorable Jeremiah J. McCarthy, a magistrate judge, who will tell you a little bit about the federal system. Others that are distinguished and here, in fact, everybody that's here is distinguished. We have the Honorable Aaron M. Perodato from the Appellate Division of the 4th Department. We have a number of other individuals who will be addressing you with brief remarks and then at lunch, but we'll start with Marianne Mariano, our federal public defender, our U.S. Attorney, J.P. Kennedy, our distinguished law professor from the University of Buffalo Law School, Matthew Steilen, and then we have a series of others whom you will hear from as well, and shortly, Hillary Banker, who is former president of ABOTA, Michael Purley, also a former president of ABOTA, and were it not for Michael, this James Otis Lecture Series probably would not exist. And he worked very hard to make it a living annual event, along with Greg Peterson from the Jackson Center. Kristen, you're here from the Jackson Center as well. You're president now of the Jackson Center, and we're very happy to have you here. Robert Bricado is an elected delegate or director of the Bar Association of Erie County, And Dan, you're here as well in representing Judge Judge Okay, you are, and we're glad that you're here as well. So, welcome to you all. I know Judge Farrelletto is going to hear about this, and I'm sorry about that, but in any event, we try to get through these introductions as best we can. Okay, are you ready? All right, let me tell you a little bit about today, because today is what? September 17th, right? And in 1787, the founders of this great nation, 39 delegates, voted to approve the draft of our United States Constitution. That in and of itself is really awesome. And so what an important celebration today is. Our Constitution, all 4,487 words of it, are inscribed downstairs in the pavilion where you entered 7 times over. If you look at the glass front of the pavilion and the ceiling, you have the United States Constitution there, all of those words, 7 times over. And our Constitution, as you know, and it's no surprise, right? The Constitution is a historic document. It is the product of hard-fought compromises reached over the course of several summer months of debates in Philadelphia. It is also a changeable document. There are, after all, 27 amendments, and it is those compromises that give this document its persevering power. So today, on this day, 232 years after the signing, we celebrate it with today's program, entitled Power, Responsibility, and Prosecutorial Discretion, and the United States Constitution. In the Constitution, as you probably know, there are 7 sections called articles. Our focus today will be Article 2, which will relate to the President and the executive power to carry out the law, and in particular, 2 clauses in that article, known as the vesting clause and the take care clause. Now, specifically, we will consider the scope and necessity of prosecutorial discretion, which involves the decision-making power in the federal system of the United States attorneys, and in the local systems, the district attorneys and sometimes the state attorneys general, to indict individuals for committing crimes and violating the law. And more specifically, we will also examine federal prosecutorial discretion as it was described by then United States Attorney General Robert H. Jackson in a very famous speech that he gave to federal prosecutors in April of 1940 at a conference of United States attorneys in Washington, D.C. It is fitting, therefore, that we should celebrate this in a United States courthouse building named after that same individual, one of the finest associate justices in the history of the United States Supreme Court, Robert H. Jackson. In our nation, the pursuit of criminal justice is critical to the quality of life of all Americans. Prosecutorial discretion is exercised virtually each and every day, and often with notoriety because of the media attention it receives. We see and hear and read about high-profile cases involving individuals like Harvey Weinstein, R. Kelly, Jussie Smollett, Bill Cosby, and Jeffrey Epstein. Nor should we forget the 24/7 coverage received by Special Prosecutor Robert Mueller's investigation of Russian collusion. And perhaps, even on a more personal level, the reality of prosecutorial discretion that surfaces in our own communities, which are regularly victimized by street crimes, street gangs, and drive-by shootings, which more or less have become the order of the day. This topic of prosecutorial discretion, and it's going to be my personal aside, happens to be quite a personal one for me. 1969 was the year I graduated from Howard University Law School in Washington, D.C. During law school, I happened to be one of a handful of white law school students on a predominantly black university campus at that time. To say that the decades of the 1960s and the 1970s were not lawless or racially charged would be an understatement, as I am certain that you know Dr. Martin Luther King Jr. was assassinated on April 4th, 1968. Our Constitution back then was being tested at every turn, and law enforcement was on a collision course with protagonists and antagonists alike. It was that societal unrest in the 1960s and the 1970s that brought the exercise of proper prosecutorial discretion to my life in very graphic terms. Immediately after my graduation from Howard Law School in 1969, I attended graduate law school at Northwestern University in Chicago. In the law school's Defender Clinic, I was a criminal defense lawyer, and my first case was a memorable one. I was assigned to represent Joe Lee Sims on a homicide charge. He was living in a poor South Chicago neighborhood at the time when he was accused of shooting and killing his girlfriend. His defense at trial was that she had a gun in her bra, that she became angry and tried to use it on him, and that during a struggle with her, he acted in self-defense. Fortunately for Joe, there was an eyewitness present who could corroborate his story. The name of that witness was Spider Webb. But unfortunately for Joe, Spider Webb disappeared right after the shooting. My co-counsel and I asked the Cook County District Attorney not to prosecute, but he would not agree. Joe Lee Sims was indicted. Miraculously, though, during his trial, we found Spider Webb at a bar where he was hanging out on South Chicago's South Side, and he testified. Joe Lee Sims was acquitted by the jury. I remember being so mad at the district attorney at that time that I vowed never to become a prosecutor. I believed he exercised bad judgment when he brought such serious charges against my client, Joe Lee Sims, and that I thought at the time was an abuse of prosecutorial discretion under our Constitution. Well, a short time after that trial, I became a prosecutor with the United States Attorney's Office in Chicago. And in 1970, 7 members of the Black Panther Party in Chicago were indicted by the same Cook County District Attorney. They were indicted for attempted murder in a shooting incident with police that resulted in the shooting deaths of Black Panther leader Fred Hampton and his close associate Mark Clark. 4 other Panthers were injured. 2 police officers were only slightly injured in the raid. This time, though, that district attorney exercised his prosecutorial discretion before trial and dropped all the charges. However, they were dropped only after a federal investigation was completed by the Department of Justice and by the U.S. Attorney's Office that I went to work for, which revealed that there was insufficient proof that any of the Black Panthers ever fired a gun at police. Clearly, to me, justice was served because this uncharging decision included both a moral sense and a legal sense, and as such, it was a discretionary decision. The framers of the Constitution likely would have agreed was guided by our United States Constitution. One final example, and then I will pass the microphone. For over 9 months in the late 1970s, I served as a prosecutor in Washington, D.C., on the staff of Special Prosecutor Richard Blumenthal. Richard Blumenthal is now the United States Senator from Connecticut. Our staff of 5 lawyers investigated unlawful disclosures during the course of a criminal case which involved bribery by an Arab sheik of state governors, United States congressmen, and United States senators. It received a lot of national media attention. The almost 1-year-long investigation itself took me and my team of 15 FBI agents to 56 different cities at a cost of well over $1 million. In the end, the prosecutorial decision was made not to recommend criminal prosecutions, but alternatively, the special prosecutor recommended that serious disciplinary action be taken as against a number of government agents. This, to many, was a truly surprising result. But nonetheless, arguably, it was an exercise of proper prosecutorial discretion because it demonstrated courage and wisdom in the charging process. And as such, it was the kind of result I believe was envisioned by the framers of Article 2. So as you can imagine, these three cases were poignant life experiences involving some prosecutorial decisions that, in my opinion, were good and some perhaps not as good. But clearly, what I witnessed back then applies today. It was the application of an important constitutional principle that was real, that affected lives, that was not abstract, and that is the focus of today's topic. Okay, now I hope you're holding on to your seats just for a bit longer. Soon, we're going to hear much more interesting information about this subject matter from prominent UB law professor Matthew Steilen and U.S. Attorney J.P. Kennedy and federal public defender Mariano. And we all are very grateful that you're here to join us today. But first, before we get to them, and they will be talking in just a minute or two, you will hear very brief remarks from former President Hillary Banker of the Buffalo chapter of ABOTA, and then from Michael Perley, ABOTA's own, and of course the driving force behind this James Otis lecture. We're going to throw in, for good measure, Magistrate Judge McCarthy. He's learning about right now, and we'll tell you about the federal system and how that works. And then all of us will be joining together for our luncheon discussion today. So hang in there, don't leave. I think you're going to really enjoy today's program. Let's greet Hillary Banker with a round of applause.
Thank you, Judge Scretany. Good morning, everyone. My name is Hillary Banker, and I'm currently a member of the National Board of Directors for the American Board of Trial Advocates, or ABOTA. I welcome you all to the 7th Annual James Otis Lecture. Founded in 1958, ABOTA is a national association consisting of more than 7,600 lawyers, equally divided between plaintiff and defense lawyers, and judges. There's 96 chapters across all 50 states and the District of Columbia. The Buffalo chapter has 33 members. ABOTA and its members are dedicated to the preservation and promotion of the civil jury trial right provided by the 7th Amendment to the U.S. Constitution. ABOTA is an invitation-only organization. Members must have at least 5 years of active experience as trial lawyers, have tried at least 10 civil jury trials to conclusion, and possess additional litigation experience. Members must also exhibit the virtues of civility, integrity, and professionalism by following the ABOTA Code of Professionalism and Principles of Civility. The 7th Amendment to the U.S. Constitution states, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States other than according to the rules of the common law. Thomas Jefferson was of the opinion that the right to a trial by jury of fellow citizens was a more important safeguard of personal liberty than the right to vote. With a jury, the rights and duties of each of us are decided by our fellow citizens. The 7th Amendment is a precious right that is increasingly under attack by those who would eliminate justice by the people in favor of justice by the bureaucracy. In 2014, ABOTA founded Save Our Juries, a public education campaign aimed at informing and mobilizing citizens in the fight to save our disappearing 7th Amendment right. An equally important mission of ABOTA is to ensure that Americans, particularly young people, understand the Constitution and the rights and responsibilities of citizenship. That is why ABOTA created the James Otis Lecture. Today we celebrate the 232nd anniversary of the signing of the Constitution. I am so glad that you are all here to join us for what promises to be a very interesting program. Thank you.
Thank you very much, Hillary. Michael Purley, please.
Good morning. I'm very happy to see so many of these faces again, having had the opportunity over the last week to talk to you about this program. Today, I'm here to introduce Matthew Steilen. I could read his biography to you. You only have a short excerpt, and you've read that already. But that doesn't do justice to the contributions Matt has made to this program since he joined us in our third year. You can read in his biography that he is an extraordinary constitutional scholar. What you can't read in his biography is his level of commitment to education, and not merely education at the law school, but education at all levels. Matt has been an integral part of our program every year, whether he's appeared in this courtroom and spoken to those assembled or not. His guidance, his thought process has helped focus our programs over the last 4 years, and certainly was influential in bringing this program together so that we could present something meaningful to you. It is my great pleasure to introduce to you Professor Matthew Steilen of the UB Law School.
Thank you, Michael. And, just so you know, Professor Steilen wrote that introduction for Mr. Purley.
All right. Now down to serious business. I want your attention for the next 10 to 15 minutes. You know our topic for today. The topic is prosecutorial discretion and the U.S. Constitution. So we're going to talk about two issues. I'm going to pose two questions to you, and I want you to pay attention to them because I'm actually going to test you on those questions as we go. The first question I want to ask you is, what is prosecutorial discretion? If you had to define the term, how would you define it? And the second question I want to ask you is, where does prosecutorial discretion come from? We're here talking about the United States Constitution. We're celebrating the Constitution. Does it come from the Constitution? If it doesn't come from the Constitution, where does it come from? Okay, so those are two questions. I'm going to take them one at a time. Let's start with the first. What is prosecutorial discretion? What does it mean to say that somebody has discretion, that they possess discretion, that they enjoy discretion? I think, at least in the last sense, we normally think that discretion is having some kind of choice. A mentor of mine, Jeff Powell, who's a professor at Duke Law School and served as a Deputy Assistant Attorney General in the Department of Justice and Deputy Solicitor General, has pointed out, he's shown that for the framers of the U.S. Constitution, discretion actually had two meanings. It meant, first, having freedom to make a choice as to how to act, but it also meant having a kind of wisdom. Discretion meant having a wisdom, an ability to manage things appropriately, and especially to manage yourself. So when the framers talk about discretion, according to Professor Powell, they're saying, in a way, two things at once. They're saying that somebody has the ability to make a choice, and they're saying that the person has the wisdom to make the choice appropriately, to make the right choice. Now, if you look at manuals today that tell you the law of prosecutorial power or talk about the limits of prosecutorial power and prosecutorial abuse, they will define prosecutorial discretion in a sense that really draws just on that choice meaning, the one I said before. So one of the leading treatises says prosecutorial discretion is, quote, the power to make a decision according to one's own judgment. But to make a decision according to one's own judgment requires, if not wisdom, as the framers thought, it requires, in the case of a prosecutor, some kind of legal understanding, some kind of skill, and some kind of moral sense. Now, to show you that this is the case, I want to look at one of the judgments that prosecutors make. Prosecutors make a wide range of judgments in the course of prosecuting crimes, but I want to focus, like Judge Scretany did, on one right now, and that is the charging decision. The The charging decision is the judgment the prosecutor makes to initiate criminal charges against someone they have reason to believe committed a crime. So let's focus on the charging decision and spend a moment thinking about the kinds of judgments it requires a prosecutor to make. Let me give you an example. This is how we do it in law school. I'm going to give you an example and use it to prime the pump to make you think about the kinds of judgments prosecutors have to make. So here's my example. Are you ready? A man is robbed of his wallet. He's robbed in the entryway to his apartment building. It happens at night. The perpetrator's there for about a minute, gets the wallet, runs away. The man calls the police. The police come. The man offers a description of the perpetrator to the police. Next day, police call back. They want the man, the victim, to come into the station to look at photographs, to see if he can identify the perpetrator in those photographs. The man comes in, looks at photographs for maybe an hour. He's struggling a bit. Finally, he selects one person. The person he selects, though, has a large scar on his forehead. In the description he offered to the police the night before, he didn't mention any kind of scar. And the person he identifies is black, and the victim is white. So the question is, should the prosecutor initiate charges? The prosecutor wants justice for all involved. The prosecutor wants justice for the victim who was robbed of his wallet. The prosecutor wants justice for the alleged perpetrator, the person identified by the victim. The prosecutor doesn't want someone guilty of robbery to go free, but the prosecutor doesn't want someone innocent of robbery to be charged with a crime, to be convicted, or to have to plead guilty. And the prosecutor wants justice for the community, which has a right to be safe and secure. So is the victim a reliable witness? Is the victim a reliable witness? There's no reason to doubt his sincerity, but there may be reasons to doubt the accuracy of the identification. He saw the perpetrator for a minute. It happened at night. He was scared, right? He was all nervous. There's no witness, no other witness besides the victim. And there's no other evidence linking the person identified to the crime. And the identification is cross-racial. And we have good studies showing that cross-racial identifications tend to be less accurate. Now, to decide whether for the prosecutor to decide whether to bring charges, think about all the things that he or she has to consider. They have to consider the law, whether the law would support a successful prosecution in this instance, whether the law would support obtaining a guilty plea. They have to draw on their experience in handling these kinds of cases. They have to draw on their skill in being able to assess witnesses, to decide whether the victim is a reliable witness. And they have to draw on their moral sense of what doing justice for everyone involved requires. That's what we mean by prosecutorial discretion. Sounds hard, doesn't it? Now, I told you there'd be a test. How would you define prosecutorial discretion? Would you define it as a power to make a choice? Would you include something else, a kind of wisdom or moral sense, legal understanding and skill to make the right choice? Okay, so that's topic one. Topic two is, where does prosecutorial discretion come from? Does it come from the United States Constitution? If not, where? Okay, so think about the example we just talked about. Where does the discretion the prosecutor enjoys there come from? Robert Jackson, in the speech that all of you have in the insert to your program that Judge Scretany mentioned in his welcome remarks, said, "The powers have been granted to our law enforcement agencies because it seems necessary that such a power be lodged somewhere." Why do prosecutors have discretion, according to then Attorney General Jackson? Because they have to. There's no other way to do it. Somebody has to have that discretion. What do you think? He's right, right? If we look at the language of the Constitution, as it turns out, it's not entirely silent on this matter, but it raises a question, and this is what I want you to focus on in my remarks, okay? Article 2 of the Constitution, which I know you have talked about for today, its very first sentence is called the vesting clause. And the vesting clause of the Constitution in Article 2 states the executive power shall be vested in a President of the United States of America. So the vesting clause vests, that is, gives the executive power to the President. Not part of the executive power, not some of the executive power, the executive power, like all of the executive power. So the question is prosecution part of the executive power? Well, historical studies have shown that the framers thought executive power meant the power to carry out the law. So is prosecution part of carrying out the law? What do you think? It seems hard to deny that it is. And the Supreme Court, in a case called United States versus Armstrong, said that prosecution is a core executive constitutional function. So prosecution is part of the executive power the vesting clause gives to the President. So now we have a problem. Think about this. The vesting clause gives the executive power, all executive power, to whom? The President. Prosecution is what? It's an executive power. So the vesting clause gives the prosecutorial discretion to whom?
President.
To the President. It turns out, it seems, that prosecutorial discretion isn't actually possessed by the prosecutor. The President, on this reading, has the power to decide when to initiate criminal charges. Of course, there's something absurd about this. And here is the lesson I want you to take away on how to read the United States Constitution. When you look at the text of the Constitution, don't read it with your eyes confined to the page. When you read the text, you have to think about how things work, how they have to work, what is required for effective governance, and what is required for justice. After all, the goals of effective governance and justice are listed by the framers in the preamble to the Constitution as some of its principal objectives. That's what they wanted. So why don't we go back to the text of the Constitution and think about how government has to function and see what result we can get. I'm going to make 3 points. Here's the first point. Is it possible for one person to exercise all of the discretion of all of the federal prosecutors across the country? What do you think? There's just too many decisions to make. That's just strictly impossible. That's my first point. That's a reason to doubt the vesting clause does what we thought it did. Here's a second point. Remember that discretion has 2 meanings. It doesn't just mean having a choice. It means having the skill or understanding or ability to make the right choice. The president might not be a lawyer. Is the president going to have the skill, the understanding, the wisdom to decide correctly when to initiate charges? Again, it just seems unlikely. Here's my third point. If prosecution was part of executive power, we would expect the actual organization of the United States government to reflect that fact. But if we look at actual history, we will see that for the first 100 years of the country's history, local prosecutors were not subject to presidential control or supervision. They were subject to no control by the central government. Prosecutors in those years operated with what one former United States attorney called, they operated in splendid isolation. The first Attorney General of the United States, Edmund Randolph, really hated this. He went to Congress and asked Congress to give him the power to supervise the decisions of the local federal prosecutors. And guess what Congress did? They look kind of like you look right now. They're like, come back later. They didn't do a thing. They didn't do anything. When Congress finally got around to subjecting local prosecutors to supervision and control, they did not give that power to the Attorney General. They gave it to the Secretary of the Treasury. But Treasury wasn't an executive department as they understood it. Treasury was a legislative department because it exercised the power of the purse, and that's a legislative power. The actual organization of the government does not show that the president ought to have control over prosecution. So let's go back to the text with those 3 points in mind and reread it. So remember, we talked about the vesting clause, and the vesting clause vests the executive power in a president of the United States, and we read that as all executive power. Well, on looking back, we have to admit It doesn't say all executive power. And if we keep reading down Article 2 into Section 3, we get to another clause mentioned by the judge, Judge Scretany, called the Take Care Clause. The Take Care Clause. What does the Take Care Clause state? The Take Care Clause states that the President shall take care that the laws be faithfully executed. Executed by someone else, not by the President. The language of the Take Care Clause suggests that the President's role is to supervise and to interfere occasionally, not actually to exercise the power of prosecuting himself or herself. Okay, so here's our conclusion. Don't worry, we're there, all right? Despite the vesting clause, the President does not possess prosecutorial discretion. The consensus view is, as the Take Care Clause implies, that the President's job is to ensure that government continues to run. And in doing that, he is responsible for deciding on major policies, setting priorities, and he does that through the Attorney General and through the Department of Justice. Okay, so I said there'd be a final test. Where does prosecutorial discretion come from? Does it come from the Constitution? Doesn't seem like it, does it? Does it come from necessity? That's what Jackson said. But if it doesn't come from the Constitution, here's what I want you to think about as you listen to our next distinguished speakers. What limits can the Constitution impose on it? If it's necessary, what limits should there be to prosecutorial discretion? All right, you guys, thank you.
Professor Steilen, thank you very much for those very insightful and very moving words. I think it's a great example of a very short presentation on the power of Article 2 as encapsulated in Article 2 and the power of words, which is very important. Thank you very much. We appreciate it. Mr. Peterson, you going to do some introductions? Oh, that's right. All right. Ladies and gentlemen, let me introduce you now to the very distinguished Magistrate Judge, the Honorable Jeremiah J. McCarthy. Judge McCarthy.
Thank you, Your Honor. Good morning, ladies and gentlemen. And Professor Steilen, I very much enjoyed your remarks. We have some very fine judicial colleagues on the state side of things, but I'm here to talk to you today briefly about how we do things here in federal court. As you know, the Supreme Court is the most important court in the land, but district courts, such as this court where you sit today, are where much of the action happens. They are the trial courts of the three-level federal court system. In fact, the drafters of the Constitution themselves gave Congress the power to create these courts. Article 3 of the Constitution states that, and I quote, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." Now, believe it or not, I was not around when the Constitution was created, although I'm told that Judge Schrader was. But I wish that they had used a different word than inferior. The Western District of New York, where you are seated today, is the trial court where Robert H. Jackson was admitted to practice law before he became a Supreme Court justice, after having served as the Attorney General of the United States. And as many of you may know, Justice Jackson was born in, was it Frewsburg? Just outside of Jamestown. Like all district courts, the Western District of New York is made up of very fine district judges like Judge Scretany, bankruptcy judges like Judge Buckeye and Judge Kaplan, who are seated here, and magistrate judges like Judges Schrader, Romer, Fascio, and myself. Federal district judges are nominated and appointed for life by the President of the United States, subject to confirmation by the Senate. This way, they cannot be removed merely because they decide a case in a way that some people may disagree with. Magistrate judges, on the other hand, are appointed for a term of 8 years. We are appointed by the district judges. And we are often said to be on the front lines of litigation. We oversee pretrial proceedings in both criminal and civil matters. We issue decisions and recommendations that shape the scope of a case, and sometimes we resolve a dispute from start to finish. I wanted to give you one example of the functions that we perform. Last night at midnight, an assistant U.S. attorney accompanied by 2 FBI agents came to my house so that I could sign a search warrant, which was very time sensitive. And I want to say to our U.S. Attorney, J.P. Kennedy, thank you very much. Every day, people are arrested, then brought into this court for arraignments, hearings, and trials. Important civil matters are also addressed here. A civil case simply means that it is not a criminal case. No one is accused of a crime. Instead, the defendants in a civil case are alleged to have harmed the plaintiffs in some way, such as by violating a plaintiff's constitutional right to freedom of speech and freedom of assembly. Now, as I said, I don't think district courts are inferior, but despite their best efforts, we also know that, being human, they are not infallible. Congress knew this too, so it developed an appellate court system to which litigants who believe that the district court erred can take an appeal. Like the district courts, which represent geographic portions of the country, appellate courts are divided into circuits, each hearing appeals from certain designated locations in the country. In our part of the country, appeals are heard by the Second Circuit Court of Appeals, and it consists of federal courts located in New York State, Connecticut, and Vermont. In total, there are 13 courts of appeal throughout the country. Decisions from those courts of appeal can be challenged in our highest court, the Supreme Court, located in Washington, D.C. Cases can also reach the Supreme Court from a state court. If the decision of the state's highest court is challenged, that challenge may be heard by the Supreme Court. The Supreme Court consists of 9 justices who hear cases from all over the country. Majority rules on this court. 5 votes is all that is required to dispose of a case. I'll let your teachers quiz you later on whether the Constitution requires that there be 9 members on the court, but I'll give you a hint, it does not. Generally, the court hears only those cases which it decides are sufficiently important, issuing what are called writs of certiorari, which allows those cases to be brought before the court. So that is how cases reach the Supreme Court, either through the 3-part federal system, district court, circuit, or appellate court, and Supreme Court, or through an appeal from the highest state court to the Supreme Court. Now, in talking about the Supreme Court briefly, I just want to quote something that Justice Jackson said when he was a Supreme Court justice. He said, "We are not final because we are infallible, but we are infallible only because we are final." Many of you may have heard that 2 weeks ago, Justice Ruth Bader Ginsburg, also known as the notorious RBG, paid a visit to Western New York, and she came to our court. She spoke to our staff, and she spoke to our judges. A truly amazing woman, 86 years old, who had just come off of 3 weeks of cancer treatments and yet found the time to visit us. For all of us, it was truly a thrill to meet her. But I like to think that for her, it was also quite a thrill to meet me. I want to thank you for your time, and I hope you enjoy your day here at the courthouse. I look forward to talking with you at lunch, and until then, I will turn to someone whose word is always final and infallible, my former law partner, Greg Peterson, co-founder of the Robert H. Jackson Center. Greg.
I know before Greg Peterson makes his remarks, Jerry, I'm glad you brought up Ruth Bader Ginsburg. She said something about Antonin Scalia, and as you may know, they were very, very close friends. They were 180 degrees apart in their legal and political philosophies. And she said about Justice Scalia that she never remembered what he said, but it was how he said it. And I think that's probably applicable to Judge McCarthy's statements today. All right, Mr. Peterson, you may go.
Wow, with that introduction, Your Honors, thank you for the privilege. And we will not talk about Judge McCarthy's time with my partner either today. April 1st, 1940, Robert H. Jackson spoke these words. It would probably be within the range of that exaggeration permitted in Washington to say that assembled in this room is one of the most powerful peacetime forces known to our country. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He gave that speech in the Great Hall in the Department of Justice in Washington before U.S. attorneys similar to the individual I will be introducing, James P. Kennedy, Jr., who is the United States Attorney for the Western District of New York, having been so selected on November 17, 2017. In this position, he is responsible for overseeing the prosecution of any federal criminal case brought within the 17 counties of Western New York. He's a big deal. And you can refer to his biography in the program. I will not recite it. However, as an introduction to the person who will be talking with him, I note this, that his time in office as the U.S. Attorney and before that in other positions in the Attorney's Office mirrored that of the current head of the Federal Defense, Marianne Mariano. And he went on to say that Marianne and he are adversaries in court, that he could not think of more worthy, dedicated, or capable opponent than she, who is the federal public defender and also the current president of the Erie County Bar Association, than Marianne Mariano. And he goes on to state that she's a terrific person and a credit to our profession. But what's most important, and you may notice this in Starbucks someday, U.S. Attorney Kennedy said that he and Marianne Mariano regularly get together for coffee to discuss issues affecting the federal courts here and issues thereof. So perhaps the question they can answer when I bring them to the podium is whether it's a latte or not. Dear ladies and gentlemen, Justice Kennedy.
Usually just black, and actually Marianne bought last time, so I owe her next time. May it please the court. My name is James B. Kennedy, Jr., and I represent the United States of America. For the last 28 years or so, I've had the honor and privilege to start every court appearance that I've made before the judges that you see before you here today, here in the Western District of New York, by uttering those words. And my link to this court, as you heard, goes all the way back to the Constitution itself, which established this court in the federal district courts in Article 3. With the Constitution having established our federal courts, Congress, 2 years later, in the Judiciary Act of 1789, directed the president to appoint in every federal district a person, quote, learned in the law to act as an attorney for the United States. I'm that person here in the Western District of New York. And I'm one of 93 such U.S. attorneys who sit here in the United States. Now, as the U.S. Attorney for the Western District of New York, I represent the people and citizens of the 17 westernmost counties here in New York State. According to the Judiciary Act, 1789 that I just mentioned, my job as U.S. Attorney is as follows: to prosecute in each district all delinquents for crimes and offenses cognizable under the authority of the United States and all civil actions in which the United States shall be concerned. So I have to ask today, do I have any delinquents in the room? Since 1870, we, as U.S. attorneys, have worked under the direction of the United States Department of Justice, and I often say that I'm honored to work for the only government agency that's named for a virtue. To say our name is to state our objective, the United States Department of Justice. When people ask me, what do you do as U.S. Attorney, I often respond that my job is to translate that abstract concept of justice into the everyday lives of those that I serve, each and every one of you, the citizens of the Western District of New York. Now, justice is often used synonymously with the term fairness, yet it's not easy to define what is just because people often disagree about what is fair. For example, the definition of justice may be dependent upon what side of this courtroom a person is sitting. Generally, the prosecutor sits next to the jury box. The defense, Marianne, sits on this side. Prosecutors may think of justice as protecting public safety and putting criminals behind bars, and we may measure justice, some of us, by the number of convictions that we have. On this side of the courtroom, public defenders, like Marianne, may think of justice as protecting their clients and their rights in the system. And thus, they may measure justice by the number of acquittals that they have. In both of these examples, the notion of justice is measured by the outcome of the process or the result. But I think that judging fairness and justice simply by focusing on the result can be extremely dangerous. And I say that because reasonable people like all the judges that you have before you here today, people like Marianne, people like me, and people like each and every one of you, we all have different ideas about what might be the right result in a given case. So in their wisdom, our forefathers anticipated this problem, and in Article 6 of the Constitution, they declared the Constitution to be the supreme law of the land. And in so doing, they essentially determined that all persons in our country would be subject to the same laws and the same process, so that no individual's view of right and wrong would predominate. Instead, through the enactment of the Due Process Clause in the 5th and 14th Amendments of the Constitution, our forefathers decided to focus more on ensuring a fair process than any particular result. And in so doing, by guarantee that all people receive the same fair process, our forefathers helped to ensure that all people have a measure of respect for the result, whatever it might be, because it was a result of a fair process. Objective facts determined objectively and rationally applied to a predetermined set of rules. That process is often called the rule of law. So if our founders established this rule of law in order to ensure justice and fairness, why do we even need prosecutorial discretion at all? To me, the answer is simple. And that answer is because mechanical rules without humanity can become inhuman. Consider the following example. A few years ago in the state of Delaware, a grandmother sent her granddaughter to her third grade class with a birthday cake and a knife with which to cut it. The teacher used the knife to cut and serve the cake, but then she called the principal's office to report the girl for bringing a weapon to school. The school district had a zero-tolerance policy for weapons, so it had no choice but to expel the girl for a year. After a public outcry, the Delaware legislature decided to pass a law to give administrators some case-by-case flexibility to modify expulsions. But the next year, a first grader in Delaware, who was excited about joining the Cub Scouts, decided to bring his camping combination fork, spoon, and knife, you know those tools, to use at lunch. He too violated the school's zero-tolerance policy for weapons, so it suspended him for 45 days. The board had no choice but to suspend him since the new law, created the year before, only provided flexibility for expulsions, not for suspensions. And because these rigid rules left too little room for discretion, they produced an unjust result. though it will probably come as less of a surprise to the judges here and to the attorneys that know me in this room than it will to you students. I think some of my greatest insight into how to use prosecutorial discretion as U.S. Attorney came to me not from the Constitution or from a legal document or even a law book. I got mine on no lesser authority than a magazine article that I picked up in the waiting room of my dentist's office one day. I'll explain. The article had absolutely nothing to do with the law. Knowing sort of your generation, you may not know a whole lot about the Constitution, at least until you started this program today and learning about the things that we're going to be talking about today. But I do know, you all know a lot about computers. And the article that I was reading was about how computers are increasingly replacing people in the workforce. And in trying to figure out how we as humans could compete against computers, the article noted that most workers concerned about losing their job to a computer ask themselves this question: what can I do that a computer can't? Yet the article noted that every time a worker would try to answer that question, they would do so incorrectly, because conventional wisdom was that although computers could do things like mathematical equations that calculate, they really couldn't do anything that required physical movement or any sort of a thought process. But the article noted that technology has been advancing so rapidly that things that once seemed beyond the capability of computers are no longer beyond their reach. The article described how computers can perform now all kinds of physical tasks and assemble everything from sandwiches to cars to other machines, and how with artificial intelligence, computers can now even engage in thought processes. So the article suggested that if we as humans want not to be replaced by computers in the workplace, we need to start asking the right question. And rather than asking what is it that computers can't do, the article suggested that we as humans should instead begin asking, how do we as humans add value? And in considering how we as humans add value, the article identified really two characteristics which set us apart from computers and machines. The first thing is accountability. There was a study out of Israel. Researchers there decided to investigate how judicial discretion, in this case, whether to let somebody out on parole, was influenced by that very important legal precept of lunch, everybody's favorite subject. Over the course of the day, the judges would approve about 35% of the prisoner's applications for parole. But that parole rate declined steadily in the 2 hours before lunch, which is where we're getting to now, almost at zero right before lunch. However, immediately after lunch, that rate spiked to 65% for those cases who were the first ones heard after lunch. So if you were a prisoner in Israel, the number of years you spent behind bars could be affected significantly by whether your parole application was the last one before lunch, in which case it was going to get denied, or the first one after lunch, in which case there was a strong likelihood you'd be granted parole. While I think we could all agree that we could develop an algorithm that would help predict recidivism and be far less capricious than these judges who are hungry in determining who should get parole, that's not going to happen anytime soon. And the reason it's not going to happen is because we as humans recognize a social necessity that other humans ought to be held accountable for important decisions. We humans feel the need to be able to hold someone else accountable for the important decisions that affect our lives. In addition to accountability, the second important characteristic that the article identified as an area where we as humans add value involves the task that we have evolved to be able to do for and with one another. I refer to it as empathy, the innate need that we as humans have to connect with one another. And it goes long back before our Constitution or before our country even existed. Back in the savannah, 100,000 years ago, if you didn't develop relationships with the people around you, if you didn't work with them to solve your problems, you didn't survive, you died. By sharing our stories and information such as where were the predators located, which berries should you eat, what water should you drink, we learned to help each other. And that ability and need to interact with and rely upon others is something that became hardwired into our DNA. And it's something that no machine, not even an emotion sensing machine, can satisfy. These value-added attributes of accountability and empathy, which we as humans crave, are also the same attributes which guide me in how I go about exercising prosecutorial discretion. When it comes to exercising my discretion as a prosecutor, the question I ask myself is not what can I, J.P. Kennedy, do as U.S. Attorney that someone else cannot. Rather, the question which guides me is, as the magazine in that dentist office suggested, is how can I, J.P. Kennedy, as U.S. Attorney, add value? As U.S. Attorney, I exercise my prosecutorial discretion in a manner that lets those that I know serve that I'm accountable for the decisions that I make. And I also exercise my prosecutorial discretion by attempting to afford a measure of empathy to all that I serve, whether victims, defendants, or members of the general public. So with that general overview in mind, I will admit that the exercise of prosecutorial discretion is really more of an art than it is a science. It does, as a professor told us, involve legal knowledge, a legal component, but it also involves, as the judge and the professor described, a moral component. Yet there are certain principles and policies and practices which are intended to promote a fair and reasoned exercise of prosecutorial authority and which contribute to a fair and even-handed administration of the federal criminal laws, which I do follow. And those principles are set forth in a guidance book that all U.S. attorneys, all 93 of us, use, and it's referred to as a Justice Manual. It used to be called the U.S. Attorney's Handbook. They renamed it, I think appropriately so, just last year as a Justice Manual. As it relates to my prosecutorial discretion, whether to charge somebody with a federal crime, which as the professor described is what he talked about, the Justice Manual generally instructs me to commence a federal prosecution if I believe that the person's conduct constitutes a federal crime, and there's a second component. Not just did the person commit a crime, but is there sufficient admissible evidence that will likely be sufficient for me to be able not only to obtain, but also to sustain on appeal? And Judge McCarthy told you about our appellate system, whether there's sufficient evidence that will allow me to sustain that conviction on appeal. Under the Constitution, my job is to enforce the laws enacted by Congress. It's not to pick and choose and to enforce only those laws with which I agree. But simply identifying what a provable offense is not enough. The Justice Manual also requires me to look at whether there's, and this is a second component, a substantial federal interest involved. And it sets forth a number of factors that I look at to determine whether there is a substantial federal interest. And those involve, what are our federal law enforcement priorities? What's the big issues facing our society today, whether it's opioids, or as Judge Scretny said, violence and crime. And Marianne's going to talk about a particular case that we handled that you guys learned about beforehand, and some of the decisions that were made in that case. What is the nature and seriousness of the offense? Are we talking about a misdemeanor, or are we talking about a murder? Is there any deterrent effect to the prosecution? Will this prosecution help deter others from committing a similar crime? What's the person's culpability? What's the person's role? What's the person's history with respect to criminal activity? How bad are they? What's the person's willingness to cooperate in the investigation and prosecution of others? What's the person's personal circumstances? What are the interests of the victims? We oftentimes, as prosecutors, are the only people that can give voice to the victims. What is the probable sentence or other consequences if the person is convicted? In determining whether there's a substantial federal interest, I also look at whether the person can be effectively prosecuted in another jurisdiction. Can they be prosecuted by some of the judges that we have here in state court? Does there exist an adequate non-criminal alternative for prosecution? We've seen federally across the country dealing with some of the drug cases that we have and drug abuse issues and the opioid issue, the emergence of drug courts is an alternative way to deal with people that are addicted. But certain considerations are also strictly prohibited and impermissible for me to consider in deciding whether to prosecute somebody. Those include things like a person's race, religion, gender, ethnicity, national origin, sexual orientation, political association, their activities, or their beliefs. I can't consider any of those. I also can't consider my own personal feelings regarding the defendant or the victim. I also can't consider the possible effect that my decision will have on my own professional or personal circumstances. Yet once I make that decision to prosecute, the manual instructs me that it is my job to pursue the most serious, readily provable crime. Other discretionary decisions which may follow once I make that decision whether to prosecute that most serious, readily provable crime are the following. Should I allow the defendant to plead guilty? If so, should I give him a charge bargain? Allow him to plead to a reduced charge? Should the defendant be permitted to cooperate? And if so, what credit, if any, do we suggest that they receive for it? What sort of a sentence should we seek? These principles I just described are guidelines more than requirements, and U.S. attorneys may depart from them whenever the interests of fair and effective law enforcement within their district so require. So that said, even the Justice Manual itself recognizes that in the end, the success of the system must rely ultimately on the character, integrity, sensitivity, and competence of those men and women who are selected to represent the public interest in the federal criminal justice process. That is, the men and women that work in my office, at the U.S. Attorney's Office. So with that, I'm going to turn it over to Marianne, who has a tremendous case study that we handled, our offices handled together, that will, I think, illustrate some of the decisions that have to be made. And I'll turn it over at this point. And she really is, it's true that we sort of came up together through the ranks. She's younger than me, but she started in the court very early, I think clerking for Judge Heckman, right? Magistrate Judge Heckman. And, but we've been friends ever since. And I think one of the things that surprises a lot of people is how collegial it is between prosecutors and defense attorneys, especially on the criminal side, and especially in federal court where there's even a smaller bar of people. We're all friends. We all care about each other, and we all understand each other's role in this process. And if we didn't have competent counsel on both sides of the courtroom, we really wouldn't be serving the people of our district. And I can't think of anyone more competent and more sort of someone who shares the same vision in terms of accountability for the decisions that she makes and empathy for the people that she represents than Marianne Mariano. So I'm going to, with that, turn it over to Marianne Mariano, our federal defender. Thank you.
Thank you, Mr. Kennedy. You know, I just want to make one comment. Think about what you've already learned and what you've been exposed to. What component parts are there to proper prosecutorial decision-making? And you've learned about a legal sense, you've learned about a moral sense. Maybe you haven't thought about that before. From the Constitution standpoint, when you think about the Article 2, you've heard about a vesting clause and a take-care clause. And I think now we can add to that a common sense clause. So let's hear what Marianne Mariano has to say.
Thank you, Your Honor. Good morning. And the last thing between you and lunch, it is not the best position to be in. So I've been the federal public defender in the federal defender's office for nearly 25 years. And as JP said, he's been my worthy opponent for the entire time. So it's kind of a privilege to be able to come and speak on a topic for which I have literally no experience. And I mean that. I've been asked to speak to you about prosecutorial discretion, and I wasn't really sure what I could possibly say, having never had the power to make any of the decisions you've heard about today. I thought I would just talk a little bit about a particular case. I think it will highlight what you're learning on this topic. I picked the case study, and JP and I worked on the facts together so that they were accurate. It involves one of our former clients. I think it highlights some of the factors that are present in any case, however. The defendant is DR. You all received a copy of the case study, and I hope you remember it. DR is a fairly sympathetic person who was very young at the time of his crime, but his crime was very serious. If we consider the actual decisions made by the prosecutor in his case, it may give you a better sense of the power the prosecutor has and how often they have to exercise their discretion throughout a case. So it's the prosecutor's job to wade through all of the facts and evidence in a case that's gathered at the end of an investigation, and they have to make several initial determinations. JP just talked about that, right? We know the obvious decisions, who, what, where. We know the first decision made in any investigation is who to charge. That was true in DR's case. Once the government decided to bring charges against DR, there were two other very important decisions that needed to be immediately made. First, DR was 15 at the time he committed this offense. So the government had to decide whether to charge him as an adult or a juvenile. And relatedly, they had to decide where to bring the charges, federal court or state court. If the government allowed DR to be treated as a juvenile or youthful offender, the charges would be in state court. He actually could be charged as he could be prosecuted as an adult in either jurisdiction. Well, once it was decided that DR would be charged as an adult in federal court, there was yet another initial and important determination to make. What charges? We know 2 people were killed and others were injured in this shootout. We know the government could charge DR with the homicides. There were gangs involved, so the government could potentially charge a racketeering offense. There were guns involved, so the government could charge DR with several different firearms offenses. DR acted in concert with others, so he could be charged with conspiring or aiding and abetting others in the commission of the offense. And you know from the fact pattern that DR initially lied to the investigators and in the grand jury when he was questioned. So he could be charged with perjury. So here are the obvious decisions a prosecutor makes: who to charge, in what jurisdiction, and with what offenses. But these initial decisions impact other aspects of the case, and prosecutorial discretion does not end after the charges are filed. There are less obvious decisions a prosecutor has great control over. For instance, who decides whether a case goes to trial or is resolved by plea? Is that a decision the prosecutor makes? The Sixth Amendment to the Constitution provides that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. So does that mean the decision to go to trial or to take a plea is the defendant's? And if so, how freely is that right exercised? Well, let's consider DR. We talked about the different charges the government could bring against him. Several of those charges would result in a mandatory life sentence without the chance for parole. Let's say the government filed the most serious charge against DR and refused to engage in plea negotiations. DR would have no choice, really, but to go to trial, since admitting guilt would result in a mandatory life sentence without the chance for parole. There is no reason not to take a chance at trial. But whose decision to go to trial was that in that scenario? Government's, right? Conversely, let's say the government does engage in plea negotiations and offers DR a plea to the charge that carries, say, a 20-year sentence, or maybe a statute that carries a 10-year sentence. DR is 26 years old at the time of his arrest. His choice in this scenario is to consider a plea offer that will result in his release from prison at a relatively young age, or to take a chance in trial and risk a life sentence. That would be quite a gamble, wouldn't it? The government has a lot of leverage in this case. In 2012, Supreme Court Justice Anthony Kennedy observed in a case called Loeffler v. Cooper that despite all the talk in the Constitution about our right to trial by jury, quote, the criminal justice system today is for the most part a system of pleas, not a system of trials. 97% of federal convictions and 94% of state convictions are the result of guilty pleas. So why do cases plea out? DR's case study gives you some insight. DR had to weigh the stakes of taking his case to trial against the government's plea offer. Under the scenario, that was DR's decision, right? His decision whether to take a plea or go to trial. But the government's decision, the prosecutor's exercise of his discretion as to what to charge, and what offer to make, at a minimum, influence that decision. Now, you know from the fact pattern that DR admitted his involvement to law enforcement before he was ever charged. So his case was always going to be resolved by plea. But let's look back at another aspect of the case study. I'd like you to substitute DR for Jonathan Marrero. Does anyone remember who Jonathan is? That's right. He was the first person charged with these murders. Jonathan was charged in state court, but for the purpose of this discussion, let's assume his case was brought to federal court with the rest of this gang prosecution, as surely it would have been. Before Jonathan was arrested, a prosecutor looked at all the information and evidence gathered in an investigation and decided who to charge. This time it was Jonathan, and decided what to charge: murder. Jonathan spent a year in jail waiting for trial. If convicted after trial, he faced a life sentence without the possibility of parole. What if the government offered a plea to a sentence of 10 years to Jonathan, or even a sentence of 20 years? Should he take it? What do we know for certainty about Jonathan Marrero? He didn't do it. We know he was innocent of the crime. It was one of the aggravating factors in DR's case that he and others didn't come forward sooner to exonerate Jonathan. We know now he didn't do it. But consider the plea offer. If he takes his case to trial, he will spend the rest of his life in prison for a crime he didn't commit. But if he goes into court and says he commits the crime, he knows he will someday be released from prison. And remember, the prosecutor believes they have the right person. They are making a plea offer to somebody they believe is guilty. So who really decides whether to go to trial or take a plea? And how about sentencing? Who decides what sentence to impose? The judges, right? As a general matter, it's within the court's discretion to determine the appropriate sentence in a particular case. Judges weigh many factors, including the nature of the offense, the need for just punishment, deterrence, the safety of the community. Judges consider mitigating factors like the characteristics of a defendant. But let's go back to our case study. What were DR's mitigating factors? Well, he was 15 at the time of the offense. He had no other contact with the criminal justice system, much less a criminal record. He was not a member of the gang, and we know the adult members of the gang used juveniles to commit crime. At the time of sentencing, when he was 26, DR was 5'4" and 130 pounds. It's roughly my height. Little heavier than me. We don't know how tall he was at age 15, though, do we? The shootout knocked some sense into him, and we know he got away from the people he had been hanging out with. We know he got, what he told me was, off the streets. He graduated from high school, and he took some college classes. By the time he was sentenced at age 26, he had been steadily employed for years, married his high school sweetheart, and had 3 young children. Ordinarily, these are factors a judge would consider before imposing sentence. But the exercise of prosecutorial discretion can significantly limit the court's discretion. I started by talking about the obvious decisions a prosecutor makes, including what charges to bring. And we discussed the power prosecution has in plea bargaining. The real strength of the power, especially here in federal court, lies in the ability to file charges with mandatory minimums. Mandatory minimum sentencing laws require automatic minimum prison terms for certain crimes, which the judge must impose and cannot lower, even for extenuating circumstances. Since the 1980s, Congress enacted many statutes with mandatory minimum sentences. The result has been a 500% increase in our country's prison population. A 500% increase, I'm not sure I said that right. In federal prison alone, population grew from 316,000 people in 1980 to 1,440,000 people in 2017. And that represents a drop from the high water mark of 1.6 million people in federal prison in 2008. Federal prison alone. If you include the state system, there are about 2.2 million Americans in jail right now. Mandatory minimum statutes play a large role in this growth. Who decides what sentence to impose? Where the prosecutor chooses to charge an offense with the mandatory minimum, he sets the floor for the judge, a minimum that cannot be disregarded even if the judge believes a lower sentence would be just and fair. So did the prosecutor decide the sentence? And if a prosecutor does decide a sentence, should they consider the personal history and characteristics of each defendant? Our program today is called Responsibility and Prosecutorial Discretion. And it is often said that with great power comes great responsibility, apparently even in the Spider-Man movie. Earlier, Matt quoted from a speech Justice Jackson gave federal prosecutors when he was the Attorney General of the United States, describing the ideal characteristics of a prosecutor. Justice Jackson ended his speech with this observation: "The citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth, not victims, who serves the law and not factional purposes, and who approaches his task with humility." We are very lucky in this district to have a U.S. Attorney in J.P. Kennedy that fits that bill exactly. Now, I have a pop quiz for you. The professor gave you a heads up. I did not. This is a multiple choice pop quiz, and by a show of hands, I ask you, who has the most power in this courtroom? The judges? Anyone? The prosecutor? Come on now. Anyone? 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 How about me? The defense attorney? Ah, you are listening. Very good. How about you? Do you have the most power in this courtroom? When you're on a jury. I think that's a great answer. But the answer is you in more ways than just that. A prosecutor's constitutional responsibility, we learned today, is to carry out the laws Congress enacts. I touched on the epidemic of mass incarceration, and I mentioned that the high water mark in federal prison the federal prison system housed about 1.6 million people within its walls. After 40 years of steady growth, I am happy to report that this upward trend has started to reverse itself. Since 2014, Congress has passed multiple pieces of bipartisan legislation to lower sentences and eliminate some of the mandatory minimums. Many state legislatures have followed suit. Roughly 200,000 people have been released from federal prison early as a result, most of whom were not represented by Kim Kardashian, but by federal public defenders around the country. My office alone has reviewed nearly 1,000 cases. How does legislative change come about? The first words in our Constitution give you the answer: we the people. It is our job as citizens to make sure our laws are fair and just. We do that by serving on juries. We do that by paying attention and voting. I hope you enjoy the celebration of the Constitution today, but I hope you celebrate the Constitution every day. Thank you.
Thank you very much, Marianne, and to all of you here that participated, thank you very much. It was just an outstanding program. To the students and their administrators and teachers, I hope you have a more profound appreciation for our United States Constitution, for what it was referred to and is referred to as prosecutorial discretion, and most particularly for the outstanding individuals who bring the Constitution to life for us all each and every day. All right, probably the most important part of this program is lunch. I think Marianne gets a life sentence because she spoke last. After lunch, all of you will get a chance, at lunch, you'll get a chance to talk with everybody, and then once we adjourn, I think you go back to school, I'm not sure. But thank you. You were really an engaging audience. We appreciate the fact that you worked hard to get here. That's really rewarding to us, and once again, to all of my colleagues. Yes, Marianne?
Judge, I just want to let the students know what DR was sentenced to, because we asked them to actually impose a sentence during their classes. DR was sentenced to 10 years. He pled guilty to a statute with a Most of you in this room are much more generous than that, so I'm going to use that to negotiate maybe a downward departure here from JP over lunch.
Okay, lunchtime. Ms. Labazetta, will you adjourn court, please?
United States District Court for the Western District of New York is now adjourned. Thank you.
Thank you.